Thank you, Joanne, and hello to everyone. Welcome, attendees. As always, we are honored that you are taking the time from your busy days, your busy schedules to join with lawyers from Gibson Dunn. Our topic today is privacy and consumer protection in the Biden administration. It's a topic that's particularly resonant today on the heels of President-elect Biden's certification as the next president by the U.S. Congress that occurred last night. Over the coming days, we will see some of the changes in enforcement in privacy and consumer protection under the Biden administration, as well as in the states, rolling out, and Gibson Dunn will be covering those through our alerts and our webinars in as close to real time as we can. And so we urge you, if you want to follow on after today's presentation and some of those developments, to look to those places in our website, gibsondunn.com, for some of that information. I'm now going to turn to my partner, Alex Southwell, who's going to take it from here.
Great, thanks. We're excited to talk to you about this really interesting topic on the cusp of the new administration, where there is undoubtedly going to be increased focus on privacy and consumer protection issues to come. In part, frankly, Vice President-elect Harris has extensive experience and prioritization of these issues when she served as California Attorney General. Undoubtedly, this will be an era of aggressive enforcement on the federal level, but frankly also on the state level, which we are also going to touch on. It's also important to recognize some of the bigger context of these issues. Increasingly, privacy, consumer protection issues are taking on anti-competitive and antitrust overtones. There are also First Amendment political implications for many of these issues. And of course, the companies grappling with these issues are often global and face a wide range of regulatory issues worldwide in these areas that they often have to navigate. The issues have broad implications across all industries and companies, large and small. Joel, that was your cue to you, but I'll just continue that.
Hi, sorry, I was on mute. Apologies.
Okay.
This is Joel.
All right, good.
I was speaking to myself. So in today's presentation, we're going to focus not only on the changes that we foresee in privacy and consumer enforcement, but also some continuity that we see, because continuity is as important as change, and that's what we're discerning in this change in administrations. And even in this area of extraordinary political tumult, we can expect much continuity and effort. And it's in predicting both how things will change and how they will not change that we're aspiring to present to you today and in the future. So back to you, Alex.
Okay, good. Hopefully we've gotten our first technical glitch out of the way. MCLE information is here with instructions to download the form. The code will be given orally during the webcast. We have a great team to talk about these important issues from across our practices and offices. We operate as a seamless global team, and there's contact information here for everyone, and there will be bios as well in the posted version of the slides and our website. Here's a quick agenda of the issues that we are going to cover. Our goal is to provide you practical guidance and updates. We invite questions through the chat. We'll try to address those during the webcast or after. As Joanne said, the slides will be available on the platform and on our website. And in each section, we're going to try to address developments in sort of three integrated sectors: supervision and structure, legislation and rules, and enforcement. So first, we're going to talk about the Department of Justice, and I'll just run right into this. Obviously, one of the biggest issues here, on the next slide, please, is who is going to be Attorney General, as that will obviously set the direction and efforts to restore the integrity and reputation of the Department of Justice. I speak as a former federal prosecutor, as we have a number of such on this panel today. And we now know that that will be Judge Garland, and also that Judge Garland's Deputy AG will be Lisa Monaco, and Vinita Gupta will be the Associate Attorney General. I think the takeaway from this is obviously these are all veteran, former DOJ senior personnel, so they bring tremendous experience in handling these issues, and that will be significant in the direction that the Department of Justice takes. We'll see significant issues, I think, with respect to positions the Department of Justice has taken on significant issues pending in the courts. There may be notable and substantial changes in position on certain issues. That will be certainly something interesting to watch. In terms of substance related to privacy and consumer protection, we're likely to see the focus really remaining on the issues like healthcare fraud, particularly things that are COVID related, and other broad scale fraud against consumers. Of course, not addressing the many, many other Department of Justice priorities, which is sort of beyond the scope of this webcast. And we've noted on the slide some focused task forces in this area. Those are good indicators of priorities and dedicated resources in the space. There's also been a particular focus on attempting to defraud healthcare providers, government agencies during the COVID pandemic, and some examples are here. On the theme of bringing in experience, I think it's also just important to take a quick aside in the cybersecurity area, which is closely related to privacy issues these days. And again, there has been a very notable lineup of strong, experienced people from the top, from Alejandro Mayorkas as the DHS Secretary nominee, many others. Just this week, there's a appointment of Ann Neuberger in a cybersecurity role on the NSA, re-elevating cybersecurity back into the NSA portfolio. All of those, I think, are indicators of the heightened priority of cybersecurity, and quite frankly, we're going to need that experience to address the threats. There's a ferocious growth of cybercrime groups and state-sponsored actors. Following the widespread SolarWinds attack across the U.S. government agencies, President-elect Biden confirmed that cybersecurity is a top priority of the administration. And we're going to see lots of foreign policy implications of this, obviously with respect to Russia, China, position on TikTok and those types of companies, 5G issues. Lots of very interesting issues there. Just wanted to take a quick aside along those lines because I think it's relevant to some of the privacy issues that we will increasingly see with the overlap with cybersecurity. But let's turn now to address the Securities and Exchange Commission, and back to Joel.
So hello, everyone. We don't yet know who will be nominated as the new SEC chair or who that person will nominate as his or her senior staff. Democratic-appointed SEC and directors of enforcement historically have generally emphasized more aggressive enforcement of activity that's perceived to affect average investors, and that should be of no surprise to our sophisticated audience listening today. And that's going to include an increased focus on how the securities markets are regulated and affect households, pension fund investors, an increased focus on Ponzi schemes, areas where traditionally the SEC has focused under an administration that kind of leans Democratic in its orientation. You should look for one or more critics of the SEC, historic critics, to migrate back into the administration. That's something that frequently happens, and we expect to happen again with this change in administration and the change in emphasis as they're staffing up the various divisions of the SEC. But again, we don't have those names yet. Someone does, I suppose, but we don't have access to them, even with all of Gibson Dunn's connections on the Hill. And as soon as we hear of them, we will be posting information about them, of course. In terms of legislative changes, the biggest single legislative change that will affect the SEC enforcement in the Biden administration ironically already happened. It happened about a week and a half ago. It was a congressional enactment buried within the National Defense Authorization Act that was enacted by Congress over President Trump's veto in late December. Was a provision that revivified by statute the SEC's ability to obtain disgorgement. Very briefly, for those of you who've dealt with the SEC, disgorgement is historically the way that the SEC has been able to obtain ill-gotten gains in connection with this enforcement activity, and they've collected billions of dollars annually at the height of their program seeking disgorgement. But that was pared back over the last couple of years in two Supreme Court cases, the Liu case and the Kokesh case, which restricted pretty significantly their ability to obtain certain forms of disgorgement. Well, this new law that was enacted last week brings that back to the forefront. Not only does it create a specific federal court remedy that the SEC can seek to obtain the disgorgement, but it also doubles the length of time that the agency can look back to seek disgorgement from 5 years to 10 years, which means that that gives the regulators, the SEC enforcement regulators, a lot more time to try to both claw back money that they consider as ill-gotten and also to do some of their investigating. It does not change the statute of limitations for the underlying SEC penalties, the SEC statutes that they investigate, but it does increase, again, the statute of limitation for things like injunctions and industry bans. And it is probably the single most effective enhancement of tools that the SEC has seen in years by having that clarified and again, that statute of limitation doubled. And as a result, the agency and its investigators are going to avoid bumping up against the 5-year statute of limitations with respect to disgorgement, and it's going to give them significant incentive to try to seek disgorgement in a way that those of us that have practiced against the SEC for years were seeing until a couple of years ago with those Supreme Court cases that I mentioned. So the next slide, slide 9, please. We're talking about SEC trends. We should expect under a Biden SEC greater reliance on whistleblower-initiated investigations. You should expect that those will, the ones that they will take up and investigate and charge will be ones that affect small investors. That's going to be something that will be a greater influence, greater emphasis by this new SEC than what we've seen under the Trump administration. You should expect a no-tolerance approach to violations, especially ones that involve public companies or large companies and affect smaller investors. And finally, in general, what you can expect under this new administration, and this is pretty typical for a shift back to a sort of a Democrat-leaning orientation, is that in close charging decisions, on close cases, they will be more often apt to charge the case than to decline to charge. That's been proven true in the past, and we've certainly seen from the trends of prosecution enforcement by the SEC over the last 4 years, they were more often than not declining to charge. At least that's been our experience based on our advocacy at Gibson Dunn. And finally, on slide 10, in terms of the SEC anticipated priorities, there's a lot of continuity here as well. And you're going to hear that resonate throughout our presentation. The SEC is going to continue to use data analytics to detect fraud. That's become a major piece of their arsenal of investigating. One area you're going to see increased activity, and this is in part due to the shift to a Democrat-nominated senior staff and commissioner, and in part it's just a natural trend, is to enforce the February 2018 SEC release and guidance on public company cybersecurity disclosures. That was a release by the SEC 2 years ago, almost 3 years ago now, that puts the onus on public companies to publicly disclose cybersecurity risks and events as part of an overall risk factor disclosure. And it requires them to disclose cyber incidents, the severity and frequency of them, the magnitude of them, and you should expect increased enforcement against companies that the SEC deems to have failed to meet this specific disclosure bar. There are some already percolating that we're aware of that they've been looking into, and we imagine that that's going to increase under this new administration, both from the pipeline of old matters and from new ones that the new SEC leadership bring. So at this point, we're going to move on from DOJ and SEC, and I'm going to turn it over to Ryan Berkseeker and to Ashley Rogers, who are going to talk to you about the FTC consumer protection enforcement. Ryan, Ashley?
Thank you, Joel. This is Ryan Berkseeker. We do have a deep team that regularly represents companies before the FTC and Bureau of Consumer Protection matters, from 6B studies to Section 5 and COPPA investigations to order enforcement and compliance matters. Based on what we're hearing from our numerous contacts within the agency, we expect that we'll see an amplification and intensification of priorities that the Democratic commissioners on the FTC have been pressing over the last several years. In many ways, we will see at the FTC this sort of continuation of some policies and some practices that Joel and Alex mentioned earlier, as well as the adoption of additional enhancement measures that may not have been pursued quite as frequently over the last several years. The FTC has been very active in recent years with respect to privacy and cybersecurity enforcement, the overlap of those issues with antitrust concerns, as Alex mentioned, and consumer protection more generally. The two Democratic commissioners on the FTC have been perhaps the most vocal in pushing many of those activities. And so we expect that attention to these issues will increase in connection with anticipated leadership changes at the FTC. Ashley, moving to the next slide, could you tell us a little bit more about what we expect to see with respect to those leadership changes?
Yep, absolutely. Hi, everyone. So a key question is whether and when President-elect Biden will be able to put the FTC under Democratic control. And just to backtrack, as a structural matter, the FTC Act provides that no more than 3 of the 5 FTC commissioners can be of the same political party. And currently, Republicans have a 3-2 majority, with Chairman Joseph Simons, a Republican, leading the commission. The commissioners do serve staggered 7-year terms, and they cannot be removed for political or policy reasons. So as you can see on the slide, the earliest expiring term for a Republican commissioner is not until September 2023. So unless one or more of the 3 Republican commissioners resigns prior to their term's expiration, the FTC would remain majority Republican. Now, there has been substantial speculation that Chairman Simons will step down, which is fairly common upon a change in party control of the White House, and which would leave the agency then with a 2-2 Democrat-Republican split. Now, if Chairman Simons resigns as expected, and now that the Democrats have flipped the U.S. Senate, President-elect Biden will have broad latitude to pick a 3rd Democratic commissioner and avoid a party split that could delay significant agency action. In the event that Chairman Simons does not resign, which we think is unlikely, President-elect Biden will still be entitled to replace him as chairman and could choose between the 2 Democratic commissioners. As a practical matter, it's very significant who the chairman is. The chairman has significant authority to set the FTC's priorities, which include appointing new FTC bureau directors and filling other key posts within the agency, as well as setting priorities on investigations and policy initiatives. The significant agency action like enforcement actions or settlements do require a majority vote, but there is significant activity that can occur outside of that formal vote as well. As Ryan mentioned, we are very steeped in FTC Bureau of Consumer Protection work, and we are closely watching who we expect to be appointed chairman. Again, the specifics of the aggressiveness and direction of the FTC's consumer protection priorities will be very much influenced by how progressive the person leading the commission is and what their particular priorities are. So Ryan, I'll kick it off to you to talk about potential for federal privacy legislation.
Sure. Thanks, Ashley. One other thing before we move on from anticipated leadership changes, I think it's important to note not just that it's important who the commissioners are and what the breakdown is between Democrats and Republicans, but it's also important to look at what happens during any interim period if there is a resignation or retirement, as is broadly expected. We are in close touch with our contacts, our Gibson Dunn contacts, who monitor events on the Hill. And if there is any sort of gap between the retirement or resignation of one commissioner and his or her replacement by another commissioner, the commission's ability to act may be hampered in that interim. So we're closely monitoring whether any sort of gap or position could be filled very quickly if it is in fact a gap does open up. Moving on to the issue of potential federal privacy legislation. Obviously, as the primary federal privacy enforcement authority, the FTC would be significantly impacted by any federal privacy legislation. In fact, some FTC commissioners have been calling for such legislation for years, as you can see in the tweet from Commissioner Wilson on slide number 12. For the last several years, there has been a relatively broad, though not universal, consensus in Washington that federal privacy legislation is needed. But legislative efforts have been hung up around two issues. First, whether there would be any sort of a private right of action for violations of the federal legislation, and second, whether the federal law would preempt state privacy or cybersecurity laws. With the results of the Georgia runoff elections this week, the likelihood of federal privacy legislation just went up significantly. And we think that's true not just with respect to comprehensive federal privacy legislation, but also potentially with respect to sector-specific privacy legislation. Ashley, what are your thoughts on that?
Yeah, that sounds right to me, Ryan. In terms of the sector-specific federal privacy legislation that we may see, certainly the control of the Senate will ease the path for Democratic legislative priorities moving forward, and a couple of specific call-outs that we may be seeing. So we may see a push to enact privacy legislation related to the COVID-19 pandemic. Controlling the spread of COVID-19 has required and will certainly continue to require tracking and tracing cases, which obviously necessitates data collection and processing activities that involve some privacy risks. Those risks have caught the attention of both Republicans and Democrats. And in fact, Democrats introduced a bill in the Senate and Democrats introduced a bill in the House of Representatives. And while both bills remain pending, now that the Senate is under Democratic control, it's certainly plausible that the bill that's introduced by the Democrats will receive some renewed attention. One other area where we may see a push for legislation is in the technology and social media industry generally. In December, the FTC issued Section 6B orders to 9 social media and video streaming companies that require them to provide information about how they collect, use, and present personal information to users, their user engagement practices and advertising practices, and how those practices affect children and teens. The FTC could very well use the results of the information they obtained through those orders to make recommendations to Congress about legislation around those issues that the agency itself would enforce. Brian, do you have anything else to add to this idea of the sector-specific federal privacy legislation?
You know, Ashley, one other specific area where we could see legislation relates to the ability of the FTC to seek monetary penalties. I know we'll be talking about this in more detail with the next slide, but the ability of the FTC to seek monetary penalties for consumer protection violations in the first instance, as opposed to violations of consent orders, is on shaky legal ground. If the Supreme Court does rule that the FTC's ability to seek these kinds of penalties is limited, we expect that there may be legislation providing the agency with that authority. This is in part because, for the Democratic commissioners in particular, the ability to seek enhanced monetary penalties for violations is a particular priority. In this way, what we might see on the legislative front with the FTC is very similar to what happened with the SEC, as Joel mentioned earlier, regarding the agency's enhancement of its disgorgement authority. You know, I think this is a nice transition, though, to the question of budget and resource allocation. The FTC's ability to seek monetary penalties and to move in the sort of muscular and aggressive way that the Democratic commissioners in particular seem to desire is really dependent on resources. And what we're hearing is that staff within the Bureau of Consumer Protection are stretched very thin, and their ability to take on a dramatically increased caseload is really limited at this time. The FTC also has been concerned by the fact that the state of California now has more privacy and consumer protection resources than the FTC itself does. And the FTC has long prided itself on being the preeminent regulator within the country of privacy and consumer protection issues. We have seen some movement recently toward increased appropriations to the FTC, but the question of whether that continues and how that pattern of appropriations plays out does bear watching moving forward. No matter what the FTC wants to do, if it doesn't have the budget and staff and resources to do it, it may be limited. One other thing to watch with respect to resources may be how the FTC uses its relationships and partnerships with other federal and state agencies as a force multiplier on consumer protection issues. We've seen some close coordination between the FTC and state attorneys general on privacy investigations, particularly in the tech space recently, to include the sharing of information and theories among those different regulators. We also expect to see coordination between the FTC and a revitalized CFPB, given the substantial overlap in the missions of those agencies, and as occurred previously under the Obama administration. Turning more specifically to the top of slide 13, Ashley, tell us more about this concept of pursuing monetary relief and the FTC's real focus on doing that going forward.
Definitely. So as Ryan mentioned, the FTC often does not seek monetary relief for first-time data privacy and security violations outside of very specific areas where the Commission has promulgated a trade regulation rule, like with children's privacy. But this could be an area where we could see a Democratic FTC push back, as Commissioners Slaughter and Chopra, the two Democratic commissioners currently, have expressly signaled that they intend to be more aggressive in trying to find a legal basis to support monetary relief in enforcement actions generally, and particularly in egregious cases, such as disgorgement of ill-gotten gains. Now, as Ryan mentioned previously, there are obviously major challenges to doing this. Certainly quantifying consumer harm is difficult, and pursuing this new approach would be a departure from years of previous agency practice. But most notably is the current challenge to the FTC's authority that Ryan mentioned for the agency to seek monetary relief that is pending at the U.S. Supreme Court. Oral argument is set for January 13th on this issue in a case called AMG Capital Management, and it concerns whether or not Section 13B of the FTC Act, which is the primary means by which the FTC obtains monetary relief, whether that section authorizes the agency to seek an award of restitution. Now, this stemmed from a circuit split that developed in August 2019 when the Seventh Circuit broke with 8 other circuits and overturned its own precedent to hold that the FTC cannot seek restitution under Section 13B of the FTC Act. Now, obviously, the implications here are very significant. If the FTC is no longer able to use Section 13B to obtain monetary relief, they would be required, in the absence of legislation, to navigate a complex procedural process in order to pursue monetary relief. So frankly, it's difficult to understate the significance of this Supreme Court case. And we have indications that the FTC is very concerned that they are on shaky ground, as Ryan mentioned. Last fall, in October, the FTC asked Congress to take quick action to amend Section 13B to provide, among other things, that the agency is permitted to obtain monetary relief, including disgorgement and restitution under that provision of the FTC Act. So this is certainly an area that we are closely monitoring, and that that folks should keep their eye on. And anything else to add to that particular piece, Ryan, about monetary relief and this challenge to the FTC's ability to do so?
No, Ashley, I think you said it nicely when you said the importance of this can't be overstated. It really impacts the FTC's mission and the size of the stick that it has to wield to bring companies into compliance. One other tool that the FTC has to bring companies into compliance is the use of its rulemaking authority and consumer protection rulemaking in particular. For the last several years, the FTC has really pursued a practice of rulemaking through enforcement. It has frequently targeted prominent players within a particular industry and, following an investigation, imposed very prescriptive standards for privacy, cybersecurity, and other issues through the resulting consent order that resolves the investigation. The result has frequently been that other players in the same industry study the requirements of the consent order and change their own practices to meet similar standards themselves. We expect that informal practice of rulemaking through enforcement to continue over the next administration. But in addition to that rulemaking through enforcement, the Democratic commissioners in particular have pointed to the importance of new legislation and rules in combating what they perceive to be abuses in the consumer protection space. Ashley mentioned the 6B study that is underway. Many of the commissioners have touted these 6B studies as potential precursors to legislation in a number of different areas. And so we'll be watching closely to see how this pattern plays out, the pattern of general investigation followed by potential rulemaking or legislation. Ashley, I know another big priority in addition to monetary relief has been the potential pursuit of individual liability for corporate leaders. I know we've heard many statements from the FTC about how this is another tool in their arsenal, another stick they can use, particularly for companies that may be dominated by larger-than-life personalities, that this may be a way to bring those companies into compliance. What are your thoughts on those issues?
Definitely. So, Ryan, you're absolutely right. Both Democratic commissioners, Chopra and Slaughter, have repeatedly insisted that individual leaders should be held individually liable in cases involving alleged misconduct by their companies so that the agency can appropriately remediate harm and, most notably, achieve deterrence. There have been several dissenting statements by both of these commissioners talking about the need for the FTC to increasingly push to find these corporate leaders individually liable. And notably, even under the current Republican-led FTC, there has been a trend of naming corporate individuals, and particularly, as Ryan mentioned, kind of these larger-than-life corporate leaders, and especially corporate leaders who are intimately involved in the day-to-day aspects of their company, liable in cases. Now, these cases have typically involved relatively smaller entities. There haven't been situations where the agency has named a leader of a major corporation individually liable, but the commissioners have signaled that they are ready and willing to do so. So, demanding individual liability is somewhat controversial, but we certainly expect to see under a Democrat-led FTC more scrutiny of executives and their attention to consumer protection issues and their involvement in consumer protection issues. And I think one thing that's very significant for listeners is that at the very least, the FTC staff can push for discovery from corporate leaders, even if those corporate leaders are not ultimately named in an enforcement action, which can impose really burdensome, massive investigatory burdens on the company and on those individuals. So this is definitely an area to keep watch on, and we're doing so as well. Anything to add to that before we transition to, unfairness actions, Ryan?
I don't think so, Ashley. Continuing with this theme of different tools in the FTC's arsenal, we do expect an increased reliance on these unfairness theories, especially with respect to data security over the coming years. Putting this into a little bit of context, since the early 2000s, the FTC has reached dozens and dozens of settlements with companies for allegedly inadequate cybersecurity. Some of these settlements have followed data breaches or other incidents, and some have not. But the majority of these settlements have focused on theories of deception under Section 5 of the FTC Act. The allegation at a high level is often that a company was deceptive because it misrepresented the adequacy of its security practices. Increasingly, we expect the FTC to rely not just on those deception theories, but also on unfairness theories. That is, even if the company's general statements to consumers about security were not inaccurate, if the measures themselves were somehow inadequate, under the FTC's theory, that could amount to an unfair business practice under Section 5 of the FTC Act. Moving on then to slide 14, again, continuing with this theme of different tools, different options for compliance. Ashley, tell us more about the potential for the FTC to find platforms liable for third-party conduct.
Sure. So even the current FTC, notably, has been quite aggressive in seeking to hold tech platforms liable for third-party activity. So, for example, in the YouTube Kids privacy settlement, the Chairman Simons and a fellow Republican Commissioner, Christine Wilson, they lauded the fact that the settlement would be changing YouTube's business model and that the FTC ordered obligations exceed what any third party in the marketplace is currently required to do. So this is an area, at least in tech, where commissioners on a bipartisan basis appear to be willing to push the boundaries of the law to impose obligations on platforms. And notably, the Democratic commissioners have dissented because they believe that a settlement did not go far enough to require platforms to police third-party content. This was in the Google matter that I just mentioned. So, we foresee that under a new chair, the FTC is likely to continue to pressure companies it believes should be policing misconduct that it should be able to control on its platform. And with that, I'll turn it over to you, Ryan, to talk about potential increased scrutiny of algorithms that employ the use of consumer data.
But thanks, Ashley. And in fact, I think we can talk about these algorithms together with ad targeting issues because in many ways they are related. This use of algorithms for automated profiling affecting the kinds of information that consumers see or are exposed to, particularly on tech platforms, has been highlighted as a concern by a number of commissioners recently. This isn't entirely new. We've handled a number of FTC investigations of these issues over the last 5+ years. And it's also been a concern in Europe for a number of years and is a focus of the GDPR. But we do expect that this will come increasingly into focus in the coming years. And in fact, that 6B study that you mentioned earlier, Ashley, also does address some of these issues, the use of algorithms on consumer data in ways that consumers may not understand based on the disclosures that companies have given to them. I know it's a particular concern for ad targeting.
Yeah, that's right. In the past, the FTC has generally acknowledged that consumers can benefit from targeted advertising, but have emphasized that consumers should have notice and choice about what data they're sharing. But the Democratic commissioners have expressed a lot of skepticism of those benefits. And Commissioner Slaughter, in particular, has argued that consumers don't really consent to wide data sharing because of the length and complexity of privacy policies, and Chopra has compared behavioral advertising models to mass surveillance. So completely agreed that this is an area where a new chairperson or a Democratic-led FTC may push for development of a theory of consumer harm regarding targeted advertising.
Finally, the last point to address with respect to the FTC is that we expect there to be an expanded and continued focus on children's privacy. This is one of the few areas in Washington where we see bipartisan consensus. It has been a particular concern of Republican Commissioner Christine Wilson, and we expect enforcement of COPPA to continue in the coming administration. Ashley, I know you and I have been very busy handling a number of investigations in this area over the last couple of years, and I expect that will continue. Moving ahead to slide 15, there's also expected to be some continuation with another agency, HHS, and in particular HHS's enforcement of HIPAA and privacy and security requirements associated with that. To put this into some historical context, we really first saw HIPAA enforcement really pick up toward the beginning of the Obama administration. And even into the Trump administration, we saw that emphasis continue. In part, that's because the pipeline for these cases is so very, very long. We continue to see investigations premised on conduct that predates the Trump administration, as well as cases based on more recent conduct. So that contributes to the sense of continuity in this space. More broadly, this is an area where the cost of enforcement resources is very small relative to the value of recoveries to the federal government. So we expect HIPAA enforcement activity to continue. One particular priority in 2019 and 2020 has been enforcement of the HIPAA requirements related to patients' rights to access their own health information. HHS has announced 13 separate settlements in this area, with the most recent in December of 2020. So we expect that the tail end of that priority initiative should continue into the next administration. A previous priority that was paused during the Trump administration was the HIPAA audit program. Under this program, HHS was able to target entities for audit, which, depending on the results, could give rise to more in-depth investigations and potential enforcement action. The program has been really paused for the last several years, but given the priority that it had under the Obama administration, and given the continuity in the team members that we have seen added to the transition team for HHS, that is, the folks who are involved in that transition and who are setting priorities for the agency going forward, are those who were involved in HHS, at OCR, and in other agencies previously. We expect that the HIPAA audit program is likely to be revived. One valuable thing about that program was that some of the public statements from the program, the audit guides, for example, provided valuable information to covered entities and business associates on what HHS's expectations for their privacy programs were. In addition, HHS has, for the last several years, been pursuing efforts to modify the privacy rule to better facilitate the sharing of patient information in connection with the provision of integrated care. And we expect those efforts, which at this point are very, very far along, to continue. Finally, with respect to privacy and HHS, the pandemic has brought an explosive growth in the use of telehealth applications. HHS has actively been exploring how to apply HIPAA protections in this context. There's a real mismatch between HIPAA's requirements, which were developed several years ago, and the way that telehealth is proceeding now. So we expect further movement on that issue, potentially in the form of legislation, rulemaking, or guidance in the coming years. One other agency that does have some overlapping responsibilities with the FTC, but also has a distinct focus, is the CFPB. So I'll pass it to Elizabeth Pepez to address issues there.
Thanks so much, Ryan, and thanks everyone for joining today. The CFPB, we're on slide 17. I'll just pause for a moment here on the Bureau, just to give a little context and guidepost on where we are with this agency and where we expect it to go. This obviously is the Consumer Financial Protection Bureau. After the financial crisis, the Dodd-Frank Act created this bureau as an independent agency within the Federal Reserve System. It is the primary consumer watchdog for consumer financial services. It is a very big dog, and by all indications, it's about to get a much longer leash. A couple of signposts as we go forward just to understand the size and scope of where the agency is today and where we can expect to see changes starting this year with the new administration. $13 billion. That's the total amount of consumer relief the Bureau has collected as of December 10th, 2020. It's got a $600 million annual budget or so. It administers 19 separate federal statutes with supervisory authority and enforcement authority that overlaps with or takes over from 7 separate federal agencies, including a lot of the traditional financial supervisory agencies. It's got supervisory and enforcement authority over large banks, depository banks with $10 billion or more in assets, as well as non-bank lenders. It's a very large group. They can expand it by rule. The original focus was mortgage lending, student loans, payday lending, but they can, by rule, regulate any other large player in a consumer finance market. Unprecedented structure. It's a single director, insulated from, until June of this year, presidential supervision through removal, also insulated from congressional appropriations, and it has massive supervisory and penalty powers. It can regulate by enforcement. It can engage in rulemaking to expand its jurisdiction. It can impose damages, injunctions, disgorgement, civil monetary penalties, and costs. And to give a sense of the scale, the statute authorizes up to $1 million per day for violations. That's in contrast to something like the FTC's $44,000 outside limit for certain violations under that act. So very significant agency. The big news now is with the change in Senate control and the change in administration. We've heard already from the president-elect that this agency is about to become much more robust in terms of its supervisory agenda and its enforcement agenda. And the highlight here, I think, for everybody is that the Bureau's mandate is very important. There's been a big focus on the president-elect's team, and I think we'll see this play out in the transition and beyond, on basically fair lending, non-discrimination, credit reporting. Critical, very important public agenda, but it is the flip side for business of metrics that are traditionally used to assess risk, control cost, and manage the business of financial services. With that, we'll go to slide 18, please. First thing that's going to be important, and I'm going to benchmark this by saying that the overview I just gave, there'll be lots of opportunities for stakeholder involvement and input as the transition proceeds, both at the Bureau itself and in Congress. Our team on the phone here, obviously a lot of us have worked in government. We'll never get today in the time we have to all of the important areas, but we have a great, obviously, respect for the public mandate at the Bureau. We've worked a lot with the agencies and with Congress, and so happy to follow up as needed on any of these areas. The thing that's going to be a really important driver, first and foremost, is the appointment of a new director. The single director structure is critical because it drives the policy agenda and also the supervisory rulemaking and enforcement priorities. On that score, we expect the transition team is being led by Leandra English. She was the former deputy director after Director Cordray from the Obama administration. She knows the Bureau very well, and we expect will coordinate very closely with the Senate in terms of the selection of a new director or nominee and confirmation, as well as input from Senate banking, and particularly Senators Warren and Brown on priorities. Some of the names that have been floated include a founding fair lending director, a House representative and former bank monitor, and an FTC commissioner who's a former executive. So we've got lots of candidates, and I think there will be a big impact we'll see unfold over the next 6 months. In addition to the appointment at the Bureau itself of the director, we will probably see, now that we have Democratic control of the Senate, some robust legislative initiatives. I listed a couple here. The first is potentially the legislative creation of a public credit reporting bureau with mandatory jurisdiction over any financial institution that's involved in federal program lending. Very significant in terms of both credit reporting. We've seen some of this, for example, in the CARES Act, in the COVID relief programming, about what sorts of reporting institutions and financial services providers have to do. There's also been a number of rulemakings and enforcement actions around credit reporting. Again, we expect the focus here to be heavily on non-discrimination in both credit reporting, information access, and consumer capital access. The other big area that's been mentioned for legislative action in connection with the Bureau's mandate is potential bankruptcy discharge for student loan debt. Very significant, huge, dollar impact, obviously, and a lot of business impact if that were to go through. Again, lots of opportunities for stakeholders to weigh in, but I think that's going to be very much part of the agenda now that we've got the Senate results from Georgia and the transition team coming in. The last piece I think we expect to see on the sort of intersection between Congress and the new Bureau leadership will be responding to some Supreme Court and other court decisions in recent years where we've had, and Ryan and Ashley mentioned this, and Joel and Alex as well, the courts have been considering questions about whether certain agencies can do things like impose civil monetary relief like restitution or disgorgement. That's the Lew and AMG cases. And then we've got on the other side of it some cases about the reach of agency authority. The Lucia case was about SEC administrative law judges and whether they had to be appointed by the president or the head of an executive department. There was some controversy around whether CFPB administrative law judges met that criteria after the Supreme Court laid it out in 2018 with respect to the SEC judges. So we've seen a relatively thin docket of CFPB ALJ cases recently. I think that's going to change. Last year, the current director decided that CFPB ALJs were in fact appointed in conformance with the Supreme Court's criteria because the Bureau is an executive agency and the director is the head of the agency who appoints the judges. The Congress could obviously, shore that up in legislation if it goes through on some of the credit reporting bureau and bankruptcy issues I just mentioned. And the other thing was the Saylor Law case in June of 2020. The U.S. Supreme Court fixed by severance, it cut out a part of the CFPB statute that insulated the director from removal by the president at will. Now that that's been rectified, the current director has ratified a lot of the Bureau's actions. That constitutional cloud, as it were, has been removed. There's some lingering questions. We saw that in yesterday's report. I think it was on the 5th. The Bureau issued a long report, task force report on issues it's facing and considering going forward, 100 different recommendations. But one of them was how to respond to the lingering issues from that Supreme Court decision in June of 2020. Congress could take care of a lot of that in legislation. Slide 19. When we talk about enforcement trends, I just wanted to give a quick screenshot of where we are now before we get to the last slide, which is going to be where we think we're going on this. Enforcement trends to date in the last 4 years have been relatively muted. You'll see in the graph the average caseload. This is, far less robust than when the Bureau was first constituted, and you saw under Director Cordray in 2011, 2012, 2013 the caseload. The significant I think, features that we're likely to see change with the new administration are in the bullet points at the right. At the moment, the scaled-back enforcement agenda reflects some of the points I just mentioned, namely some cloud over what the administrative law judges could do and this constitutional controversy about the director's authority. Those have been resolved. And now we also had a prohibition in the Trump administration on regulation by enforcement, where the agency kind of goes case by case and basically makes law as they adjudicate. Very tough for stakeholders to anticipate what the rules of the road are, huge stakes in terms of the penalties, so there's a lot of pressure to settle. The current administration, the Trump administration, had kind of pulled back on that. We expect that to reverse. And we also expect to see a more robust focus, as we did back in 2011, 2012, on large banks rather than on smaller lending firms and more egregious conduct. When you go to the agency website, you can see some of these trends. They talk about recent actions, and you can see the difference if you compare the last year or so of reported actions and settlements to, say, 2012, when we saw, Capital One, American Express, large banks, very large restitution and penalties by contrast. And structurally, the Trump administration also imposed some limits on the Bureau's activities. It relocated the fair lending enforcement function to the director's office. We expect that to change with the new administration, see more autonomy there, as well as the Trump administration had imposed some limits on the enforcement office initiating their own investigations without director and input from other agencies. We expect that to likely change. And then also the elimination of rules and guidance that the Bureau had previously promulgated. The current administration, the Trump administration, left that for congressional reauthorization. We expect a more robust rulemaking function, budget function in the CFPB going forward. Slide 20. The look ahead. Again, we can't do anything but predict what we're seeing from the transition reports, but I think it's fair to say the quote at the top of the slide about reversing the Trump administration's efforts to weaken the Bureau and holding financial institutions accountable for discriminatory practices. That quote from the Journal was sourced to the President-elect's transition team and reflects, I think, fairly the priorities that we can expect from Ms. English's transition group coming into the Bureau and the policy agenda that they've been discussing publicly and also with members of the Senate Banking Committee. On that score, I think what we can expect out of the transition are recommendations, both in conjunction with Senate Banking, for a new director who's going to take the Bureau in a more robust rulemaking and enforcement direction, consistent with a big emphasis on credit reporting and non-discrimination and fair lending. I think we will also see recommendations to reverse many of the constraints the Bureau has faced that were outlined on slide 19. And there may also be, frankly, several recommendations to pursue legislation. So that's the transition bucket. For regulatory, this is where I think we're going to see some really significant increase in activity. The Bureau, by statute, is authorized to use rules to regulate additional non-bank providers of financial services. So we're going to see in the fintech space, peer-to-peer lending, lots of new initiatives. The Bureau may try to do some of this on its own by rulemaking or in conjunction with legislation, given the new change in Senate control. They're talking about things like licenses, basically the equivalent of bank charters for fintechs or other non-bank providers. And there's a tremendous amount of room for the Bureau just in its own rulemaking process to reach out and regulate any entity that it believes is engaging or has engaged in conduct that poses risks to consumers in regard to the offering of consumer financial products or services. That's very broad. We got a sneak peek at it. There was a case several years ago where the Bureau initiated an action against Verizon and Sprint wireless carriers based on what they called, the Bureau alleged, was cramming of certain charges for things like specialized ringtones on people's phone bills. There was a dispute about whether the Bureau, in fact, had jurisdiction to reach wireless carriers. The case was settled That was several years ago. I expect to see a return to a more robust view of the Bureau's jurisdiction that could reach many entities that wouldn't normally think of themselves as regulated. And also on the rulemaking front, I think we can expect to see a reversal or reinstatement of some very broad rules that impacted a lot of industries. One was a prohibition on arbitration clauses with consumers. Others address discretionary pricing that auto lenders and other businesses offered people with different credit scores on the basis that it violated equal credit opportunity or fair lending principles, payday lending rules, and credit reporting. So really significant, I think, prospect for some rule changes that will have an immediate impact across industries. Structurally, we expect there's going to be reversal of some of the constraints on slide 19 insofar as more robust funding, investigation authority, more robust administrative law proceedings in front of the ALJs, partnership with other agencies, and on the enforcement side, hand in glove, we're going to see a much more robust enforcement agenda with an emphasis on using all of the many tools the Bureau currently has in terms of restitution, damages, injunctions. We usually see 5-year consent decrees and civil monetary penalties, which again can range from $5,000 to $1 million per day per violation to advance conduct in these industries, and to do it on a basis where it might be a surprise because it's coming in the form of an enforcement action for the first time or as part of a new rule. So very significant prospect. I think we'll have to watch how they unfold in which channel legislative or at the Bureau itself. Lots of opportunities for stakeholders to weigh in, but look forward to seeing what happens and to being of help to anyone as these developments unfold.
Okay. This is Mylan. I can take it over from here. Thank you, Elizabeth. So the first and most important thing I'm probably going to say for all of you is for all attorneys participating in this webcast, please note the MCLE passcode is 4534. And I'll just repeat the code again to make sure you've had an opportunity to write it down. 4534. This code must be included on your MCLE form to submit for credit. My name's Mylan Dinnerstein, and one of the areas that I practice with in Gibson involves state attorneys general. And as you can imagine, and I'll be very brief, the focus of this presentation was largely on the impact the transition is going to have on the federal government, but it's also going to have an impact on state attorneys general. So we'll briefly focus on that for a couple of minutes, and I will try to be as brief as possible. First, as many of you are aware, over the last 4 years, mainly Democratic state attorneys general have spent a large portion of their resources and time and energy and press opportunities suing the president and his administration in a wide range of areas. And frequently, New York and California were often leading the charge, joined by other states. And again, these have typically been Democratic AGs, as you all know. State AGs have sued the Trump administration over, hundreds of times in the last 4 years. It's interesting to note it's more than double the number of suits that state AGs previously filed against the Obama or Bush administration, and each of those administrations lasted 8 years. So that's going to change because, as you can imagine, AGs are no longer going to be focused on suing the administration, particularly Democratic AGs. By contrast, you may see more suits against the administration from Republican attorneys general where they believe there is overreaching by the federal government. So an example of that I can think of that may or may not occur is in the context of COVID, if there are certain executive orders that relate to the global pandemic that state attorneys general believe they can challenge, I'm sure they will. But one thing to keep in mind is regardless of the federal administration and who is in charge, in many cases, attorneys general are aligned, and we expect that to continue because it just doesn't matter who is the president. So many AGs will continue to pursue areas that they collectively think are appropriate. You can see that in antitrust lawsuits recently. You can see that in tobacco cases from the 1990s. You can see that in the national mortgage settlement in 2010. So that we expect to continue. So I think the point that I think I'm hearing from my colleagues is that they expect to be a more robust federal government in terms of investigations and enforcement actions. I don't think that's going to stop attorneys general from investigating and participating in enforcement actions. I think you're going to continue to see attorneys general use their offices to, which frequently they have broad enforcement powers, particularly with respect to consumer protection and data privacy, continue to pursue those areas quite aggressively. They may partner with the federal government. They may choose to proceed on their own. But I don't think we're going to see any kind of decrease in enforcement from attorneys generals moving forward. And in particular, I'd like to point out that many states are facing significant budget deficits, and not only in 2021, but in the out years. And from my perspective, I think that raises the possibility that attorneys general in the next 4 years will really be seeking substantial penalties, especially if the funds can be used, in their view, to the state's benefit. So with that, I'm going to turn it over to my colleague Amanda to speak specifically about the New York Attorney General's office.
Thanks, Mylan. So the New York Attorney General, Letitia James, has primary enforcement authority over consumer protection and data privacy in New York. As Mylan mentioned, she is an AG of a populous state. She is often at the forefront of these coalitions, some of which are bipartisan, some of which are democratic on major nationwide issues. As you can see here on the slide, she has spent significant time doing battle with the Trump administration. AG James has only been on the job since the beginning of 2019, so in large part her tenure has been defined by her challenges of the Trump administration. So, in her first year of office, 2019, she filed 29 lawsuits against the Trump administration. This last year in 2020, despite the pandemic, that number jumped to 37. But she, will be reallocating resources. She won't be challenging the Trump administration anymore. And so we expect the New York AG to spend more time focusing on bread and butter issues, the environment, labor, civil rights, criminal justice reform, health, and of course, consumer protection and data privacy. Now, of course, she also, a significant portion of her tenure, nearly half, the last 10 months, has been in the COVID-19 pandemic, and she's spent significant time and resources to investigating complaints about price gouging, fake medical products, and other fraudulent practices that have preyed on consumers during the pandemic. So these kinds of efforts will undoubtedly continue into the new administration until the pandemic is over. AG James also views her office in New York as leading the charge on issues of data privacy, cybersecurity, and big tech antitrust. She is leading bipartisan coalitions of attorneys general in the recently filed antitrust suits against big tech. And she regularly brings big data privacy and cybersecurity related actions. We expect these trends to continue. One thing that we're watching is in November, the election also had an impact on the makeup of the New York legislature. Senate Democrats took a veto-proof supermajority for the first time in New York State history, so they will hold unprecedented power next year. And at the top of their lists are criminal justice reform and privacy and tech legislation. So we expect that new laws will give AG James new authority to effect change in the criminal justice reform space. But also as it concerns data privacy and consumer protection, the AG already has a number of tools at her disposal for consumer protection and data privacy, like, as many states have these general consumer protection laws and business fraud statutes. And in New York specifically, she's got the SHIELD Act, which is New York's new cybersecurity law that went into effect in March 2020. But New York does not yet have a general consumer-focused data privacy law like California's. And New York really wants to be a thought leader in this space and catch up with California. So the Democratic legislature is anticipated to move forward on a general privacy bill, something along the lines of California's. And there are at least 4 proposed bills similar to California's that have been proposed in prior sessions. So we would expect to see something like those be revived in the coming legislative session. Now, of course, the AG in New York is the primary enforcer vis-a-vis the incoming administration on data privacy and consumer protection issues. But the Department of Financial Services, or DFS, has also given some indications that she'll wade into this territory. The DFS superintendent, Linda Lacewell, is a former federal prosecutor. She has staffed her office full of former federal prosecutors, and she's taken an aggressive stance towards enforcement in her jurisdiction. Technically, her jurisdiction is over insurance companies, banking and financial institutions, and their related companies and subsidiaries. This includes cryptocurrency companies. But she's taken a broader view of her jurisdiction and influence and has used the department's power to exert influence even over industries and subject matters over which she doesn't have jurisdiction. So this summer's Twitter report is an example of that. For those who don't know, in about mid-July, Twitter was hacked. The hackers took over some prominent accounts like Barack Obama's, Kim Kardashian's, and tweeted a double your Bitcoin scam from those Twitter accounts. The governor directed an investigation. DFS superintendent took up the charge, and in October, she issued a scathing report on the Twitter hack, despite any authority over Twitter. She called for broad regulation of Twitter and other social media companies, making sweeping statements about the need for strong cybersecurity to curb the potential weaponization of major social media companies. Now, as you can see on the slide, she also took this opportunity to praise DFS-regulated cryptocurrency companies, basically saying, if you play ball with us, you'll get praise, like the cryptocurrency companies, and if not, we will crush you in the court of public opinion. So we would expect to see some more of that going forward in the new administration. Basically, DFS Superintendent Lacewell continuing to take public positions that puts pressure on companies related to data privacy and consumer protection. Now I will turn it over to our San Francisco partner and a former federal prosecutor, Winston Chan, to speak to the California Attorney General.
Winston?
Thanks a lot. And my colleague Victoria and I are pleased to be giving you this coast-to-coast coverage of AG trends and where we think things are going to be going in the future. And for the California AG, it has been and will continue to be a major player in the AG space, both for regulatory reasons, of course, but of course investigations and enforcement. I think we have seen, those of us who are in the government investigations and defense group here on the West Coast have seen over the last couple of years an increasingly robust, increased willingness on the part of the California AG to get in there and compete with federal agencies for enforcement priorities and to bring cases and investigations against big companies. The reason for that, as some of you may know, is that the statutory scheme in California is very favorable to the breadth of the AG's power here. The unfair competition law in California essentially lets the AG investigate almost any kind of corporate wrongdoing under the guise that the commission of whatever act of wrongdoing we're talking about enabled the company to unfairly compete with its competitors and therefore get an unfair advantage. And that's usually how its corporate investigations are framed. But the immediate news going on in California, right, is who will be the next AG. As I'm sure many of you know, the current AG Becerra, has been nominated by Vice President-elect Biden to become the next HHS secretary. It's sort of a surprise given that Becerra isn't a traditional nominee for that, having not sort of been engaged in healthcare work or been in healthcare himself. But that nomination leads to a whole bunch of musical chairs going on in California. The pieces moving around are that with Kamala Harris becoming the vice president, we'll have a new senator appointed there, and the name put forward there is Alex Padilla, who is the current Secretary of State. Replacing Padilla will be Shirley Weber. And then there's been a lot of prognostication about who will replace AG Becerra. And we don't know, or at least I don't know any sort of inside baseball on that, but some of the more heavily covered names in the state include these three on the slide: Rob Bonta, who is a legislator, Diane Becton, who is the current DA of Contra Costa, and Dennis Herrera, who is the San Francisco city attorney. I mean, I think it's safe to say that we won't see a huge change in priorities when and if any of these three, let's say, for example, become the next AG. They're all similarly very sort of progressive, and at least when you look at their past priorities and their respective positions. They're very progressive. If anything, Dennis Herrera, who has been city attorney for quite a while, it might be sort of seen as maybe a little bit more experienced than the other two in terms of these kinds of cases and working together with federal partners and other county and city partners in terms of bringing broad-based consumer protection-related actions. Of course, the nominee here will have to be someone sort of not just who will please various constituencies, but also is electable because they'll have to go on to be able to run for statewide office. And in terms of priorities, right, I think it's a lot of what everyone else has been saying in this panel, which is that a lot more of the same, for sure. You have cases that have already been pursued, and there are a lot of priorities that will continue on. I think that in the last year, what we have seen is an enormous focus by the California AG on employee-related issues. And one of the units in the California AG's office is the Workers' Rights Bureau. And we've seen them have an outsized influence in the past year with respect to COVID-related cases, so investigations focused on health and safety of its employees, and also compensation and employee status cases of gig economy companies. But with that, I'll turn it over to Victoria to get into more specifics.
Thanks, Winston. Like Winston said, whoever's appointed into the role, we think there's going to be some common threads that we're going to see looking forward into 2021 and beyond. First, of course, just like with the New York Attorney General and some of these other Democratic attorneys general, we're going to see a reallocation of resources away from suing the federal government. More than any other AG in the country, Becerra has sued the Trump administration over 100 times. Interestingly, more than half of those were environmental lawsuits about environmental changes or rollbacks of regulations. So I think that shows how important environmental regulations and the Environmental Justice Bureau, which was recently created by AG Becerra, how important that's going to be looking forward. But it's a massive amount of resources that's going to be redeployed internally into the state of California and away from the federal government. The California Department of Justice is the only second in the country to the U.S. Department of Justice, and so this is going to be a massive reallocation. Some particular additional specific areas of enforcement priority we think we're going to see going forward, like Winston mentioned, employment, COVID-related issues. Let's see. Next slide. How about that? Perfect. Of course, privacy and cybersecurity. California has seen a sea change in its privacy laws over the last couple of years, and the California Attorney General plays a central role, first in drafting the very regulations it's going to be enforcing, and it's recently just completed that exercise for the CCPA, the California Consumer Privacy Act, which has been enforceable since July 1st of 2020. And those regulations have now been finalized in effect since August. So for the CCPA, to date, we've heard reports of the AG issuing compliance letters out to businesses seeking information about their practices. We haven't yet seen any public enforcement actions or settlements, but we do believe that's going to change in the coming year now that the regulatory effort has mostly concluded there. We also are going to see with the newly passed California Privacy Rights Act, this was just approved by the voters in November. This is CCPA 2.0, and that is creating yet another privacy enforcer in California. It's going to create the California Privacy Protection Agency, which is going to have concurrent jurisdiction with the Attorney General to enforce California's privacy laws. And the CPRA also creates additional protections and additional rules that expands the CCPA. And we're going to see, as the new privacy agency comes online, we're going to see, again, regulations and rulemaking there, and we're going to see more enforcement. That new agency has a baseline budget of $10 million a year, but all of the funds from these settlements that we're going to start to see in the privacy space go back to fund more privacy enforcement. It creates this positive loop. And like what Mylan said earlier about the state AGs being aggressive, in the enforcement space here, we're definitely going to see that for privacy as well as under the unfair competition law, again, seeking out those larger settlements in order to fund more enforcement. So the privacy enforcement we expect is going to really take off steam, and as it does, it will only further more enforcement in this space. Additionally, antitrust, continued scrutiny of Silicon Valley. The Attorney General's Antitrust Unit has aggressively enforced the Cartwright Act, which is California's antitrust law, as well as the unfair competition law. And some recent cases that we've seen, again, the Attorney General joining the federal DOJ's antitrust lawsuit against Google. The AG has been active in the healthcare antitrust space, recently reached a $575 million settlement against a large healthcare company for alleged anti-competitive practices. And the Office of Antitrust Unit also does merger review and has sought to challenge mergers even that have been approved by the DOJ and the FCC. So we expect we're going to see that. Environmental, again, we touched on the Environmental Justice Bureau. Consumer protection, broadly speaking, under the UCL is just going to ramp up. And again, criminal justice reform. So with that, I'm going to turn it back to Joel to take us home.
Well, thank you, and we have just a couple of minutes left. Thank you for listening and joining us in this conversation today. We hope you found it helpful. We hope you found it informative, and we hope that over the succeeding days and weeks before and after the inauguration, we'll be able to bring more information to you, as I mentioned at the outset of our presentation, about changes and tangible changes in staffing, for instance, that we hope to be able to tell you about. You can obtain a copy of the slides from Gibson Dunn on our website. You can contact any of the participants, any of the lawyers participating in today's presentation, both about what we discussed or to obtain slides or any other materials that we make publicly available on the topics we've been discussing. Again, you've heard about the MCLE information. I want to again remind you of the code, which is 4534. Again, 4534. And in the remaining minute, I just want to note that one thing that we didn't touch on as much because we were trying to cover so much material with these changes, is that so much of this that we encounter as practitioners crosses over the different terrains, the different regulatory realms that we deal with. There were most of the cases, I think, if you were to ask the lawyers from Gibson Dunn on this call, that they involve themselves with on behalf of clients don't involve just one of these agencies, but often several at once. And sadly, that leads to piling on and inconsistencies and repeated demands for the same information, and sometimes demands for relief for the same set of conduct from several agencies. And that, sadly, is not going to reduce with increased enforcement activity in the area of privacy and consumer fraud in the next 4 years. If anything, it's going to increase. And being able to navigate between those different agencies that want to sort of have their piece of the pie in enforcement is something that we're all going to have to face. So thank you all once again for joining us. It's been a pleasure and a privilege to talk to you. And on behalf of all of my colleagues at Gibson Dunn, we hope you have a good day and a good new year.